So the issue in the Deepwater Horizon case involved BP as an additional insured under the insurance coverage that the owner of the rig that blew up the Deepwater Horizon, which is owned by Transocean. Transocean purchased a very large liability insurance program with roughly $1 billion of limits, and named BP as an additional insured. And the issue in that case was whether BP is an additional insured with the same rights as any other insured under those insurance policies, or whether it was an additional insured only to the extent that the contract between Transocean and BP for leasing the Deepwater Horizon rig required Transocean to provide insurance. So that was the issue. Was once you're an additional insured, do you get insurance for any purpose, or is your insurance limited to the minimums of the underlying drilling contract or service contract? And the Texas Supreme Court took an approach that I think surprised both sides. The insurers were arguing that everyone in the industry knows that additional insured coverage is limited to the minimums required in the drilling contract. And so therefore, it doesn't really matter what the insurance policy says. The understanding in the industry is your coverage is so limited. BP's response to that was no, there was a Texas Supreme Court decision in 2009 that provided coverage that went beyond the scope of the service contract. So the Texas Supreme Court has already spoken. The litigation began in Louisiana and went to the Court of Appeals that governs the federal courts in Louisiana, which is called the Fifth Circuit. And the Fifth Circuit initially agreed with BP following the earlier Texas Supreme Court decision. The insurers then asked the Fifth Circuit to ask the Texas Supreme Court whether it still adheres to that position. So that's how we got to the Texas Supreme Court. What the Texas Supreme Court did, again, surprised everyone, as I said. And the reason is that instead of saying, we're reading the insurance policy language and we are agreeing with you, BP, or we don't need to read the insurance policy language because there's a custom and practice in the industry, the court said the insurance policy limits coverage to the minimums in the underlying drilling contract, but then never identified any language in the insurance policy that said that, because there wasn't any. So BP then moved for reconsideration of that ruling and settled with Transocean while that petition was pending. The court had asked for further briefing, which is an indication that they probably realized they had done something wrong, but not necessarily an indication that they would reconsider their decision, but they have been known to on that court. But that's where the case settled. So as things currently stand under Texas law, there's a rule that doesn't really matter what the insurance policy says. So that, I think, has caused a great deal of uncertainty among insureds who are trying to confirm their coverage. And I know a number of clients that have simply changed their policies where it used to say Texas law governs any disputes to make it New York law or English law, because there's much more certainty under New York law or English law, because both of those jurisdictions say read the insurance policy. Whereas Texas, now you don't really know. Was there a unique exception just for Deepwater Horizon, or is this a new rule in Texas that what the insurance policy says doesn't really matter? So that's where we are. It's had a fairly significant impact. But I say this with a caveat, which is that the Insurance Services Office, which is the entity that promulgates standard forms, changed the language of their standard additional insured endorsement in 2013 to expressly limit additional insured coverage to the minimums required in the service contract. Most insureds use that language now. Insureds with some bargaining power will insist on broader language, like CG 2010, which is the original additional insured cover, and will refuse to have the narrower ISO coverage. But the insureds without bargaining power, smaller companies that really don't care that much, will have narrower coverage anyway. And then there's a final point, which is that among large energy companies, they tend to be self-insured for at least smaller risks. And by smaller in the context of something bad that happens to an energy company, I'm talking about 5 million, 10 million, 20 million, 50 million. Some energy companies, the BPs of this world, for example, say that they're completely self-insured, which isn't 100% true, but it's close. And so if they're going to get insurance for an accident where a contractor is involved, it's through the additional insured coverage provided to them by the contractor. So this also makes a difference to energy companies.